if the United States continues driving crypto offshore, there will be more offshore companies, more companies in the offshore deregulated mold of FTX. And so it seems to me it would be in the interest of consumer and investor protection to bring crypto into a workable but rigorous regulatory regime here in the United States. FTX fraud has no greater friend than the status quo, no greater friend than congressional inertia. New York State has shown that it is possible to create a rigorous regulatory regime for crypto without causing the apocalypse for 9 decades of securities law. So there's the question of whether Congress should create a new regulatory framework for crypto, as New York State has successfully done, or whether Congress should seek to fit crypto within the existing federal framework for regulating financial assets, which strikes me as the more probable outcome. If Congress elects to adapt the existing framework rather than create an entirely new one, the question then becomes which digital assets qualify as securities and which qualify as commodities or something else. But if an asset qualifies as security, then there's the question of registration, and that's where blockchain technology has run into a buzzsaw. Even if Congress were to pass a law that provides perfect regulatory clarity as to which assets are securities, none of it matters if there's no workable path to registration and compliance. And under the status quo, SEC registration is little more than a mirage for blockchain businesses. The number of blockchain businesses that have found a workable path to registration is close to zero. One observer put it cogently, quote, "The SEC has created a world where project founders are required to register as ice cream while making freezers illegal. Good luck." So my question to Mr. Swihorn, how can Congress best tailor registration to accommodate blockchain technology without compromising investor protection?
Thank you, Congressman Torres. I think that's a very good way of thinking about it. My client certainly, and nobody I know that's respectable in the blockchain space, believes that it should be unregulated, that we need fewer regulations. That they want a system that sort of gives them an out. I think they want tailored regulations. As I said in my testimony, there are a lot of SEC rules and part of the federal securities laws that are sort of a round peg and square hole when it comes to digital assets, because they're just different. And if you compare the white papers that came out during the ICO boom and compare them to a prospectus, they're obviously a lot shorter, there's a lot less information, but there's also a lot of information that is not in SEC prospectuses because digital asset purchasers have interests in other topics that are not ones that the SEC in its forums have asked about.
And as I understand, Mr. Gensler himself has said that the SEC has tailored disclosure requirements to accommodate the particularities of industry. So there's nothing unprecedented about the notion of tailoring. Go ahead.
That's correct. The SEC has adopted particularized disclosure regimes for certain assets. They've not done so at the moment for digital asset securities.
The SEC statutorily is designed to be a merit-neutral regulator, but it hardly requires a suspension of disbelief to imagine a regulator who has a personal or ideological antipathy for crypto and therefore seeks to regulate the industry out of existence. But even if you're a critic of crypto, the fact remains that regulatory sabotage of crypto is the antithesis of merit-neutral regulation, which is the kind of regulation that Congress contemplated for the SEC. So how can Congress ensure that the SEC is in fact a merit-neutral regulator, and how do you prevent the use of the registration process to punish or sabotage an industry that has fallen out of political favor?
Thank you. I don't want to impugn the motives of anybody at the SEC. They're hardworking and good-meaning and are, I think, acting in good faith. But they are subject to the securities laws. Congress has mandated that they apply the securities laws as Congress has written them. I think their incentive is to make sure that the securities laws are followed, as at least they interpret them. I think if Congress wanted to make it more likely that there would be a workable path, Congress would need to mandate that the SEC adopt something that is actually functional and possible for the market to comply with.
And a distinction's been drawn between regulating financial activity and regulating the technology that underlies the activity. Some people call it regulating applications versus regulating protocols. When crafting a regulatory framework, how should we think about that distinction? Should financial regulators be limited to their core competency of regulating financial activity rather than the underlying technology.
Of course, the one challenge with digital assets, as I think Mr. Gorfine said earlier, is that you can have a car title, you can have a home title, an NFT, or a security, or a commodity, and they're all a digital asset of some sort or another. And I think, we in this country do regulate different items and different assets differently depending on what the risks are, because the risks of buying a house are different than the risks of buying a security. So there would need to be a way to differentiate in terms of whether this asset is an investment product. It is really
Gentleman's time has expired.